I'm John Leonard. I'm a corporate lawyer in Denver, Colorado with Fairfield and Woods. We have a series of videos on our website regarding various aspects of the law, where we explain things, hopefully in a simple and entertaining manner. Today, we're talking with Mark Smith about intellectual property, trade secrets, trademarks, copyrights, and patents. And we just did a couple of videos on trademarks. Today, we're going to turn to copyrights. First of all, what is a copyright, and how do you make it, or how does it become into existence?
A copyright is a right that attaches to a creative work by a human being. It must be done by a human, but it encompasses the protection of any expression of an idea. That expression may be done by text, such as a story or a newspaper article or an email, or it may be done by photography, video, or other means of recording that preserves that expression. It must be fixed, that is, preserved in some form before the copyright attaches. If you were to give an extemporaneous speech and there was no recording of it, no transcription of it, there's no copyright that attaches to that. It only attaches upon its being fixed in some form. It can be electronic or hard copy, but it has to be fixed in order for that copyright to attach. And it attaches immediately upon the creation of the work.
Without registration or anything?
That's correct. Even without any subsequent act by you, it is
automatic,
fixed at that point.
And you said something that was interesting, that copyrights protect expressions of ideas, but not ideas. What's the difference?
The copyright,
or how do you protect an idea is what I really meant to say.
well, the ideas are also protected in intellectual property, but in a different area. The area is trade secret or patents.
So it's important to come in and talk to you when you have intellectual property, because you might have a mishmash of ideas and expressions, and there's trade secrets might protect everything at the beginning, but as you migrate it out into the public, getting proper counseling on, well, this we protect by a patent and this is copyright, is really the counseling that you're giving at the very beginning of the creative process. That's good. We already talked about you don't have to register a copyright, but talk about why you would and what that process is. How do you register a copyright and what protection does it give you?
All right, once you have created a copyrighted work and it's yours, you the owner. If you're the sole owner, that's fine. If you're a joint owner, you need to have both people involved with this process of registration. But the registration is a means by which you provide the Copyright Office, which is a section of the Library of Congress, with a specimen of that work in some form. And you go through the application process, which defines who the author was, when it was produced, when it was created, when it was published, if it was published, the nature of the work and the scope of your claim of copyright. It could encompass and include pre-existing work that is not yours, but you still may have a copyright, but it would be only as to what you contributed to that individual piece of work.
In some works, I guess like a movie or some things might have different aspects about it. I'm thinking like a movie, you might register a copyright for the book or the screenplay, and then another one for the actual visual movie. So once you're thinking about registering a work at the Copyright Office, there may be multiple registrations.
Yes, there will be. You can have copyrights can attach to, say, a song. You can attach it to the lyrics or the lyrics plus the melody. You can attach it to a performance of that. So there are various levels of copyright that kind of encompass any work of art, whether it's written art or visual art.
And so if I infringe, let's say I have a work that's substantially similar to a registered copyright or a work that has a registered copyright, as the infringer, what would that expose me to potentially?
They have infringement is a strict liability tort. And tort is merely a term of art in that legal field, but it's strict liability. It doesn't matter if you innocently copied something or intentionally copied it, you're still going to be liable. It's just the degree to which you're liable. And if it's a registered work at the time of the infringement, you are at risk not only for damages, actual damages that party may have incurred, but as an alternative, statutory damages, which can be up to $150,000. And then in addition to your being at risk for statutory or actual damages, you have the potential of being responsible for their attorney's fees. So it is a substantial risk that you should seek to avoid in the copyright area.
And so when you advise your clients about seeking multiple copyright registrations for various aspects, you would take, for example, a top $150,000 infringement. You could start multiplying that times 2, times 3, times whatever. And so when you're advising a business or a sophisticated client or any client, you would help that client determine what to register and in what tranches, what chunks, so as to maximize the ability to, hopefully, if there's an infringement, you could just write a letter to say, cease and desist, because I've registered it so many times, you would really get clobbered, I guess. I don't want to use too many technical terms there, but now registering a copyright isn't expensive.
No, it's the cheapest protection you can buy in the federal government. It's about $65 for a single registration.
And you fill out just a few boxes. Even a lawyer can.
Even a lawyer, but a lot of lawyers make mistakes in those registrations.
Right.
Because if you don't do it right, you're going to have either to file a supplemental registration, or you're going to have to defend your error at the time of trial.
Right. Well, we just talked about all things copyright. Copyright is something that arises by operation of law. It just happens when it's put into a fixed, tangible form. Do you have to register with the federal government? No, but you'd be crazy not to, because it's the cheapest, best protection you're going to get for intellectual property, I guess.
That's exactly right.
So
it's very powerful, but very cheap.
Get good counseling on your intellectual property. Call Mark Smith is the message that you need to hear. Thanks for joining us today. Please check out our website on other videos we've done on intellectual property and other aspects of law meets business and your personal life. Thank you.